From Uncovered DC. Why is the Supreme Court involved in Pennsylvania? By John M. Reeves, November 10th, 2020. Last Friday evening, in the midst of the media frenzy over the presidential election, Justice Alito issued a short page-and-a-half order to all Pennsylvania county boards of election. The order directs the county boards in counting ballots to separate any and all ballots received by mail after November 3rd at 8 p.m. from those received before that time. Most legal commentators minimized the significance of Alito's order, declaring it to be no big deal. In fact, though, the order is part of a major lawsuit currently pending before the Supreme Court, the outcome of which could have serious consequences for election law across the country, regardless of whether it practically impacts the results of the presidential election. As such, it is to be hoped that the court will agree to hear the case in full. This article is the first of a two-part series. Here, we will examine the underlying legal issues and the factual background of the case. The second article will clarify for the general public the complex procedural matters that have taken place in the case. Background to election law under the Constitution. The lawsuit, the Republican Party of Pennsylvania versus Kathy Boockvar et al., presents the question of whether, under the United States Constitution and federal law, state courts can overturn the express enactments of state legislatures regarding the time, place, and manner of holding presidential elections. The Constitution vests the state legislatures with the authority to do this and mentions nothing about state courts. The federal Congress, in turn, is vested with the authority to pass a law mandating that all states hold the voting for president on the same day throughout the country. For a major part of our country's history, Congress declined to exercise this power. As difficult as it is to believe in this day and age, there was a time when different states held their elections for president on different days. But Congress eventually streamlined the election process by passing legislation mandating that the presidential election be held on the first Tuesday after the first Monday in November. But while Congress, pursuant to its constitutional authority, has mandated the date on which the presidential election must take place, the individual state legislatures are still vested with a large amount of discretion to decide the place and manner of the elections. For example, while Congress has set the date on which the election is to take place, it has said nothing about the closing time by which all votes must be cast on that date. Should the polls close at 5 p.m., 8 p.m., this is a prudential matter left to the resolution of the individual state legislatures. Even more critically, should mail-in voting be allowed? If it is, how should it be done? Do mail-in ballots need to be received by election day itself, or is it sufficient for them to arrive later so long as they are postmarked the day of the election? Again, this is a matter of prudential judgment left to each state legislature. But in any event, the Constitution vests resolution of these matters with state legislatures, not with the judiciary. Pennsylvania. Now we come to Pennsylvania. Until last year, Pennsylvania election law only allowed ballots to be submitted through the mail if the voter demonstrated he or she would be absent on election day, the traditional absentee ballot. Absentee ballots, furthermore, had to be received by the respective county board of elections no later than 5 p.m. on the Friday before election day. But then, in 2019, Pennsylvania state legislature, known as the General Assembly, revised this law to allow mail-in voting for any reason, in addition to absentee voting. More critically, the Pennsylvania General Assembly did away with the requirement that ballots sent through the mail be received by 5 p.m. on the Friday before the election. Now, in place of those requirements, all votes submitted by mail must be received by 8 p.m. on election day itself, in this case, November 3rd. But the legislation does not consider as valid any ballot received after 8 p.m. on the day of the election. The resulting litigation. nobody disputes the above provisions of Pennsylvania law. It is also undisputed that these procedures do not violate the Constitution. Nevertheless, this past September 17th, the Pennsylvania Supreme Court issued an order directing the Pennsylvania Secretary of State and all Pennsylvania county election boards to accept as legal all mail-in ballots received up to 3 days after November 3rd, contrary to what the General Assembly passed. But that was not all. The court also said that mail-in votes had to be counted even if they lacked a postmark indicating they had been sent out on election day itself. In other words, the Pennsylvania Supreme Court ordered the election boards to continue to include as valid votes lacking any proof that they were actually cast on November 3rd, 2020, the day Congress has set for the presidential election. Not surprisingly, the Republican Party of Pennsylvania was dissatisfied with this order and accordingly filed a petition for a writ of certiorari with the United States Supreme Court, which is still pending. In other words, the court has not yet issued an order on whether to accept the case, but because of the matters at issue, it is highly likely the court will take the case, regardless of whether or not it changes the final vote tally in such a manner as to decide the presidential election. Why is this important? This case is about far more than the ultimate winner of the presidential election. It is also about far more than allegations of election fraud. More importantly, it goes to the heart of who has the final say in deciding how presidential elections are to be conducted, the state legislature or the state judiciary. As noted above, the Constitution vests state legislatures and not the state judiciary with the authority to set the rules for presidential elections. There is no ambiguity about the language in Pennsylvania's election law. Only those mail-in ballots received by 8 p.m. on election day are valid legal ballots. Any received afterward are invalid. All parties in the case agree that these are the rules that the Pennsylvania General Assembly implemented for the presidential election. And everybody agrees that, of themselves, these rules are not unconstitutional. Nevertheless, the Pennsylvania Supreme Court ruled that because of potential hardships some may experience in mailing in their ballots, the November 3rd, 8 p.m. deadline had to be extended by 3 days to Friday. The court admitted that no law explicitly gave it the authority to extend this deadline, but it nevertheless concluded that it could extend the deadline not on federal constitutional grounds, but rather on the nebulous provision of the Pennsylvania state constitution providing that section elections shall be free and equal, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. Pennsylvania Constitution, Article 1, Section 5. It did this despite admitting there was no evidence of any civil or military power hindering people from voting on election day. By purporting to rely on the Pennsylvania state constitution and not the federal constitution or federal law as the basis for extending the deadline, the Pennsylvania Supreme Court is hoping to avoid having the U.S. Supreme Court review it. Review by the U.S. Supreme Court is only available when the issues relate to federal law. If the issues are purely state law, the U.S. Supreme Court has no authority to hear the case. Not surprisingly, those opposing the Republican Party's cert petition of certiorari, have raised these arguments as grounds for denying the cert petition. But it seems to me that the opponents of cert, as well as the Pennsylvania Supreme Court, are on thin ground. The U.S. Constitution explicitly vests authority to determine the manner of presidential elections with the state legislatures, not the state judiciary. If concerns existed that may have justified extending the deadline to receive mail-in ballots, those are concerns that the Pennsylvania General Assembly was empowered to address, not the Pennsylvania Supreme Court. Under the guise of applying purely state law, The Pennsylvania Supreme Court has, in effect, usurped the Pennsylvania General Assembly's authority under the Constitution to determine the time, place, and manner of presidential elections. In other words, the case is about preserving the ability of state legislatures to make their own prudential judgments about how best to conduct presidential elections and not be second-guessed and overridden by the state judiciary. This is not a matter of state law such that the Supreme Court cannot review it. Rather, it goes to the very heart of the U.S. Constitution's vesting of such authority with the state legislatures. As such, it is entirely about federal law. Indeed, the case boils down to the very manner in which the U.S. Constitution structures the state legislatures as participants in presidential elections. Given this, the court will hopefully hear the case of how or if its resolution affects the outcome of the presidential election. The issues are too important on their own for the court to ignore. And now we go to part 2. Introduction. This is part 2 in our analysis of Republican Party of Pennsylvania versus Kathy Boockvar et al., the case currently pending before the Supreme Court of the United States involving Pennsylvania election law. It is unclear at this point whether the court will agree to hear the case. In part 1, we examined the substantive legal issues presented in the case, namely that the Constitution vests state legislatures with the authority to determine the time, place, and manner of presidential elections, and that the state judiciary has no authority to usurp this function. Here, we will discuss the case's current status and what has gone on so far. We will also try to clarify some of the more complex procedural aspects of Supreme Court litigation. As the Supreme Court actually agreed to hear the case, what did the earlier 4-4 split mean before the court refused to order the Pennsylvania Supreme Court to segregate out the ballots? Why has Justice Barrett not been involved in the case so far? Why was Justice Alito and not one of the other justices the one who issued last Friday's order? And what does Justice Alito's most recent order mean? Certiorari petitions versus stay applications. What's the difference? Two things are actually pending before the court right now. The Republican Party's petition for a writ of certiorari and its application to stay and recall the mandate of the Pennsylvania Supreme Court. While similar, they are two separate things. As most who follow the court know, a petition for a writ of certiorari is a party's legal brief asking the court to agree to hear a case. The Supreme Court, with a few exceptions not relevant here, does not have to hear any of the cases that come before it, unlike a normal appellate court. A cert petition presents the legal arguments for why the court should agree to hear the case in the first place, and opposing counsel may submit a brief arguing why the court should not hear the case. If the court does grant a cert petition, it orders each party to file briefs arguing why its side should win and sets the case for oral argument. If the cert petition is denied, that's the end of the case. An application to stay the mandate is part of a lesser-known aspect of Supreme Court practice. Normally, the filing of a cert petition by the party that wants to challenge the lower court's ruling does not put the enforcement of the lower court's ruling on hold. The cert petition does not stay the ruling. In other words, the ruling being challenged will go into effect while the Supreme Court is disposing of the case. The lower court issues what is called a mandate with its opinion. The mandate is what makes the lower court's order enforceable, and the mandate is in effect while the cert petition is pending. Accordingly, if a party who wants to seek cert thinks that it will suffer irreparable harm if the lower court's order is enforced while they seek cert, it can apply for the lower court's mandate to be recalled and stayed pending the disposition of the cert petition. But normally, the party has to seek a stay of the mandate from the lower court first. Only if the lower court denies that request may the party then apply to the Supreme Court for a stay. A stay application is very difficult to obtain. The party must show it has a reasonable chance of the cert petition being granted and that it will suffer irreparable harm in the absence of a stay. Under the rules, the party must apply to an individual justice and not to the court as a whole. The justice to whom the application is made is determined geographically. Each justice is assigned to oversee a particular federal appellate circuit for stay applications, which includes all state courts within that circuit. Thus, Justice Alito is assigned to the Third Circuit, where Pennsylvania is located. The need for a stay of the mandate in the Pennsylvania case. Given the above, it is easy to see why the Republican Party sought a stay of the Pennsylvania Supreme Court's mandate that ballots received after 8 p.m. on Election Day be included in the vote tally. Under the normal time frame for Supreme Court litigation, it was highly unlikely that the court would be able to resolve the case before Election Day, even if it granted the petition, order full briefing, and heard the case in full. If the court agreed to hear the case and subsequently ruled that all votes received after Election Day were invalid, that would mean that the total vote count in Pennsylvania would need to be reduced by the number of votes received after Election Day. But if the court issued its ruling after Election Day, how would Pennsylvania be able to separate the valid votes from the invalid votes? Recognizing this quandary, the Republican Party of Pennsylvania first asked the Pennsylvania Supreme Court to stay its mandate pending the cert petition's filing. The Pennsylvania Supreme Court denied this, so the Republican Party of Pennsylvania applied to Justice Alito for a stay. In other words, they asked Justice Alito to order that any votes received after November 3rd at 8 p.m. not be counted towards the total vote tally, but rather be segregated from the total vote count, pending the resolution of the lawsuit by the entire U.S. Supreme Court. That way, if the Republican Party won the case, the results of the vote count, it would be easy to calculate the final vote count without the post-election day ballots. If the Republican Party lost the case, on the other hand, the post-election day ballots already segregated and accounted for could easily be added to the total vote tally. The standard practice of the court in recent years is for an individual justice to refer a stay application to the entire court if it raises a serious issue. That is what Justice Alito did here. He referred the stay application to the entire court. By this time, Justice Ginsburg had passed away, and Justice Barrett had not yet been appointed to the court, meaning only 8 justices considered the application. On October 19th, 2020, again, before Justice Barrett had joined the court, in a 4-4 split, denied the stay application due to it being a tie. The order declared that Justices Thomas, Alito, Gorsuch, and Kavanaugh had voted to grant the stay application. This denial meant that the Pennsylvania Supreme Court's ruling would go into effect and that all votes received after Election Day would need to be included in the final tally while the U.S. Supreme Court considered whether to hear the case. The Republican Party then filed for a petition for a writ of certiorari on October 23, 2020. It also filed that same day a motion to expedite consideration and resolution of the entire case in the hopes that the court could come to a final ruling before Election Day on November 3rd. Again, this was prior to Justice Barrett joining the court. On October 28, 2020, the court issued an order denying the motion to expedite consideration of the case. Justice Alito, however, issued a statement attached to the denial order. Justices Thomas and Gorsuch, but not Kavanaugh, joined this statement. Many have wrongly interpreted this statement to be a declaration that the court should have expedited the matter and agreed to resolve it before Election Day. That is not what Alito said in his statement. Rather, Alito declared that while he agreed there was not enough time to resolve the case before Election Day, nothing prevented the Republican Party from reapplying to the court following Election Day to ask that any ballots received post-election be segregated from those received by 8 p.m. on Election Day. Critically, Justice Alito's statement on October 28th concluded by stating, quote, "We have been informed by the Pennsylvania Attorney General that the Secretary of the Commonwealth issued guidance today directing county boards of elections to segregate ballots received between 8 p.m. on November 3rd, 2020 and 5 p.m. on November 6th, 2020. Nothing in the court's order today precludes the Republican Party of Pennsylvania from applying to this court for relief if, for some reason, it is not satisfied with the Secretary's guidance. As we shall see later on near the end of this article, it is critical to keep this final sentence of Alito's statement in mind when we examine Alito's subsequent order. Why didn't Justice Barrett take part in deciding whether to expedite ruling on the cert petition? By this point, Justice Barrett had joined the court, and the order included a declaration that she had not taken any part in considering the motion to expedite ruling on the cert petition. While some members of the public were surprised by her not taking part in the case, the explanation is most likely quite simple. Once Supreme Court justices are appointed to the bench, they must still take 2 separate oaths before they can actually begin their work on the bench. This is nothing new. It is a tradition that has been in place since the early 1790s. The first oath is the constitutional oath, common to all federal employees. The second oath is the judicial oath, which is unique to judges. Until judges take both of these oaths, they cannot even view, let alone take part in, the internal deliberative process of the court they are about to join. While President Trump appointed Justice Barrett on October 26th, and the public saw Justice Clarence Thomas administer an oath to her that evening, what the media broadcasted from the White House that evening was Justice Barrett taking the first oath, the constitutional oath. But even after taking that oath, she was not entitled to take part in the court's deliberative process. She still had to take a second oath in order to begin work. She took this oath the following morning, on October 27th, in a private ceremony inside the court. Again, there was nothing unusual about this. It is part of a long-standing tradition of how new justices are sworn in. Given that the court issued its denial of the motion to expedite the very next day, October 28th, it is difficult to see how Justice Barrett could have familiarized herself with the legal aspects of the case in time to take part in the vote. This may seem frustrating, but it is plain reality. It has nothing to do with a purported reluctance by Justice Barrett to participate in the case. What did Justice Alito actually do last Friday, November 5th? After Election Day, the Republican Party of Pennsylvania applied to Justice Alito for an order directing the Pennsylvania Secretary of State to segregate all post-Election Day ballots from all ballots received by 8 p.m. Election Day. It declared that the Pennsylvania Secretary of State had not, in fact, been implementing the guidelines for segregating ballots that it had issued on October 28th, despite telling the court itself that those guidelines would be implemented, and despite Justice Alito, in his earlier statement, noting this representation by the Pennsylvania Secretary of State. Under the guidelines that the Secretary presented to the court on October 28th, the post-Election Day ballots would be segregated, but not canvassed. That is, not counted towards the final vote. But on November 1st, the Secretary, without informing the court, posted updated guidelines directing that, while post-election ballots were to continue to be segregated, such post-election ballots would also be canvassed. That is, that such ballots should be counted towards the final election total. In addition, the Republican Party's application declared that while the Pennsylvania Secretary of State had the authority to issue guidelines to county election boards for segregating ballots, the Secretary did not actually have any legal authority to require the counties to adhere to such guidelines. The Republican Party also noted that 25 Pennsylvania county boards of elections have not declared one way or another whether they are segregating the post-election ballots. Justice Alito's order last Friday, November 6th, related to the above. In it, he directed all Pennsylvania county election boards to comply with both the October 28th and November 1st guidelines of the Secretary. That is, that post-election day ballots be segregated from other ballots and that, quote, in all such ballots, if counted, be counted separately, end quote. Justice Alito also noted that, quote, until today, the court was not informed that the guidance issued on October 28th, which had an important bearing on the question whether to order special treatment of the ballots in question, had been modified, end quote. In addition, Justice Alito observed that the Republican Party's, quote, application informs the court that neither the applicant nor secretary have been able to verify that all boards are complying with the secretary guidance, which, it is alleged, is not legally binding on them, end quote. Justice Alito concluded by stating that he was referring further resolution of the application to the entire court and directed that any response by the secretary be filed the next day, November 7th. The secretary responded in the following day in a short 2-paragraph letter. It declared that all 67 Pennsylvania counties have, quote, confirmed their understanding and intention to follow the secretary's guidances set out on October 28th, 2020 and November 1st, 2020, end quote. The letter was silent on whether or not the counties were in fact following the guidance. The letter simply declared that the counties had confirmed their intention to follow the guidance. Nor did the secretary dispute that it had no legal authority to compel the county election boards to follow its guidance. Both the Democratic Party of Pennsylvania and the Luzerne County Board of Elections also filed responses. The Democratic Party declared that no evident reason exists for a county board to refuse to follow the secretary's guidance, but likewise did not dispute that the secretary could not legally bind the county boards of election to act in a certain way. The Luzerne County Board of Elections, in turn, declared they were following the secretary's guidance, but likewise did not dispute that the guidelines were not legally binding on them. What happens next? Both the stay application and the cert petition remain pending before the court. It is not clear at this point how it will rule on either. The other side has until November 25th to file a response in opposition to the cert petition, but it is possible the court may rule on it sooner than that. In addition, as noted above, 4 justices, Thomas, Alito, Gorsuch, and Kavanaugh, originally voted in favor of staying the mandate. Given that a stay is appropriate only if a justice thinks a reasonable chance exists for the court to grant cert, it would seem that these 4 justices are in favor of granting cert here. And because only 4 votes are needed to grant cert, it would seem that the court will agree to hear the case. In any event, the court will most likely rule on the stay application by the end of this week. John M. Reeves, an appellate lawyer in St. Louis, is the founder and owner of Reeves Law, LLC. A native of Chicago, he graduated from Washington University in St. Louis in 2004 with both a Bachelor of Arts and Master of Arts in History, having earned his master's degree with 4 years of undergraduate study. Mr. Reeves likewise earned his law degree from Washington University in St. Louis, graduating in 2007. He spent 6.5 years as an assistant Missouri Attorney General in Jefferson City, Missouri, before returning to St. Louis and entering private practice. Mr. Reeves has authored over 250 appellate briefs, including several in the Supreme Court of the United States. Find him on Twitter at Reeves Law STL.
I will be the greatest president that God ever created.